Let's start out by just having you introduce yourself. Give us your name and where you were born and a little bit about your history, where you went to school and grew up. I read from your bio that you were born in Mount Sterling, and maybe you could tell us a little bit about your Kentucky roots.
Well, I was born in Mount Sterling a long time ago, and I grew up mostly in Mount Sterling. Graduated from high school there, and that was during World War II. So 5 days later I was sworn in and went on active duty with the Navy. When I was in the Navy 2 years and 5 days, and when I came out of the Navy, I came to UK. I had some college training while I was in the Navy, both at Berea College and at St. Mary's in California. And in those days, you didn't have to have a degree in order to go to law school, so I only needed a little bit more work before I started to law school, and I graduated then in 1949 and started practicing in Lexington, where I practiced for a long time.
Well, what was it that interested you about the law? Why did you choose that for your profession?
I was going to be a naval officer because back in the days when I was in high school, it was always the naval officer in his white uniform that got Betty Grable. And then I was on the debate team at my high school, and a lawyer judged the debate one time and asked me if I was going to be a lawyer. And I got a book about Clarence Darrow. I read that book and took his advice, and I went to law school and was a lawyer ever since.
How large was your law school class? Do you remember?
No, but most of the people in that law school class were returning veterans, because this was right after World War II, and the GI Bill of Rights had come in, and that offered the greatest opportunity that this country, I think, has ever offered young men, principally because in those days there weren't very many women. There were a lot of women, but there weren't very many women in the law school. Two, I believe, maybe in my class. And I forgot the question.
Well, your experience in law school, is there anything that stands out in your mind about your law school class or your professors, or any outstanding experience while you were in law school? Or?
Probably the thing I most remember about it is I clerked for a law firm downtown, and I found out what real life was like. And that made my last semester in law school the longest part of my life, because it went on and on and on, and I wanted out into the real world. And ultimately ended up in the real world, I guess.
So you graduated law school in 1949?
1949.
And started practicing then in the late 40s, early 50s in Lexington.
Well, in 1949
1949, so...
Right, August the 10th.
August the 10th. So do you have any memories of some of those early cases that you had when you were just starting out, those in 1949 and the early 50s?
Well, yes. I was very fortunate. I had clerked for Tom Mooney, who was at the time mayor of Lexington, and his firm had been dissolved because he'd had a serious illness, and so when I graduated, I suggested that he and I form a firm. You know, 23 years old, I guess, something like that. And I thought I could form a firm with the mayor, and sure enough, we did. We did, and that firm was called Mooney and Turley, and we practiced together until he died. So he was a wonderful person, and he was the kind of mentor a young lawyer needs. He took it for granted that everything would be done right, that everything would be well done, and that he didn't even think of doing anything wrong. And that's the way I was taught. It's the way I was raised in a small town like Mount Sterling. As I was growing up, all the adults in town knew who I was, because that's the way it is in a small town like that. And if you misbehaved, your mother knew about it before you got home. And it was a good experience for a young person. And then to practice law with Tom Mooney just added to everything. And I had some subrogation cases. I don't know who's going to be hearing or watching this, so I will explain it, not for the benefit of the lawyers, because they all know, I expect. But subrogation cases are where an insurance company has paid a claim arising out of an accident of some kind, an automobile accident usually. And then they stand in the shoes of the person they've paid when they sue the other person that caused the wreck. At least that's the allegation. Caused the wreck. If I get paid and you caused the wreck, my insurance company will sue you in subrogation. And in those days, we tried small cases. I mean, we tried about every case. A lot more so than today, I think. And those small cases, I tried all over eastern Kentucky. And in those days, we also had what was known as contributory negligence. And again, for those who are not lawyers, contributory negligence means if both parties are negligent and the accident results from the contribution of the negligence of both parties, neither can recover from the other. That's no longer the law in Kentucky. We now have comparative negligence because we finally figured out that probably both people were somewhat at fault in most accidents. And when one of them was really badly hurt and the other one wasn't, we could compare the degree of negligence and the degree of causation, and we would get a far fairer result. And that's the law now. But in those days, when I was trying subrogation cases, we had contributory negligence, and I lost 7 straight cases, I remember. Because contributory negligence beat you to death. Do I remember that? Yes, I remember that. And I remember when I first started practicing, anybody that had a legal problem that came in the office, we'd be glad to take care of writing wills, divorce cases. That's the first thing I quit doing, was divorce cases. Adoption of children. Well, we had one case that I remember when I was young. In those days, it was called a bastardy case. People don't use that language anymore because we're much more refined. But in those days, that's what it was called. And an unmarried woman who accused her lover of having produced her child would sue him, and if he were found by the court to be the father, then of course he would have to pay maintenance for his child. Well, nobody had ever heard of DNA in those days. And I'm talking about 50 years ago. I'm talking about the early 50s. But they had just started Central Baptist Hospital, and I happened to know a couple of the doctors out there, and one of them was sufficiently well trained and knew that he could compare blood samples and tell whether they came from people who were related. And so he did that in my case, and the man whom I represented was found to not be the father by a blood test, and was cleared of that sort of charge. That didn't happen much in those days. The blood testing, I don't remember other blood testing being done, but I knew Dr. Chips, and he did it. Other cases, I guess all kinds of cases, until you come to the place in the practice, and I guess all the lawyers know this. You come to the place in the practice where you have more clients than you can take care of, and you have to do one of two things. You either have to add people to your firm so there'll be others to help you take care of your clientele, or you have to decide you're going to specialize and not take everything that comes in the door. I remember the last divorce case I had was tried at about the time Tom Mooney died, because when business had increased to the point that I could sit on any more divorce cases. So you go one way or the other, and I went in the direction of having a smaller law firm so that I could participate in what was going on, and always did have a small law firm. Probably 6 is as many as we ever had in my firm. I'm off counsel in a firm now where there's 6 partners and 2 off counsel, so I guess I've turned off counsel, and I don't decide how many people are going to be in the firm.
What were your memories of the courtroom and how the courts operated? How's that changed over the years?
Well, the courtroom in which I tried most of my cases is still in town. It's been changed. It used to be higher, and it had a tin ceiling, a metal ceiling. Now that's still there, but you have to go up the steps to get to it, because they've added, of course, to that courtroom. They sent all of us out to try cases at St. Joseph Hospital, or what had been St. Joseph Hospital, out on 2nd Street. That became our courthouse. We tried cases out there while they were rebuilding or remodeling what is now the History Museum, the Lexington History Museum. And I remember Melvin Belli tried a couple of cases in Lexington, one in federal court and one in state court, and he came to Lexington to try one of those cases over at what had been the St. Joe Hospital when they moved out on Broadway. I will say this about the trial practice in the practice of law in those days. There weren't very many lawyers. There were about 200 in Fayette County. Not all of them tried cases. Some were real estate lawyers or corporate lawyers, and But those who came to the courtroom came every Saturday morning because that was motion hour. And whether they had a motion on the docket or not, they were there. And the judge, because when I started practicing, there was only one circuit judge, Judge Chester Adams. He knew all of the lawyers. And he would call them by name, ask every one of them, do you have any motions? Do you have any motions? And the lawyers knew each other. And there was a collegiality at the bar that I'm told no longer exists. Part of it because you're running into the same lawyer again and again. And if you're going to be ugly to him, or if he's going to be ugly to you, then you're going to have that same sort of problem every time you have a case with him, or every time you have any sort of a problem in which you're both involved for different clients. As the bar grew, I suppose that had something to do with it. Now, I'm not complaining about the way lawyers treat me, because I've had very few occasions where I had a complaint like that. A few. Bushwhacking. Where in trial, a lawyer will ask a question that he knows is not proper to try to get it before the jury. And an objection is sustained to it, but the jury's heard enough that he's accomplished his purpose. Now, there's a rule to take care of that, Rule 11, but it's not utilized as often as it probably could be. If you object to that sort of thing, that just underlines it for the jury, so it's not a very good way to deal with it. There wasn't as much of that in the early days of my practice as I saw somewhat later on, and there was some of it. Some of it ended up in the Court of Appeals, but they don't like to get involved in that sort of thing.
So how were lawyers reprimanded? I know things have changed a little bit because there's, like for instance, most complaints about attorneys now are directed to the Kentucky Bar Association. They're not handled locally, but I don't think that was always the case.
I guess in the early days it was just a matter of if a lawyer did something that was sufficiently improper, he could be disbarred. But bushwhacking wasn't that sort of an offense. I wouldn't justify it. I'm not trying to justify it, but at the same time, in those days, there wasn't any Rule 11, but the judge could be in control of his court. One of the problems that we've had at the bar in any state like Kentucky, which elects its judges, is the fact that some of the judges that we elect want to stay on the bench, and because they have to come up for election again, and depending on what judicial post they hold, they want to be nice to the lawyers because they don't want all the lawyers going out talking bad about them, and they let lawyers get away with things that probably they otherwise wouldn't. That doesn't happen so much in federal court, because in federal court the judges are not elected. They're appointed by the president, confirmed of course by the Senate, and then they have a lifetime position. At one time in Kentucky, at two times in Kentucky, one that I remember, we had what was called a Federal Judicial Selection Commission. The then two senators, and we've always had two senators in Kentucky. When I say then, I mean the ones who were in those offices at that time, agreed with the Kentucky Bar Association and produced a charter signed by the two senators and by the Bar Association that each would select 3 people, making a total of 9, who would become the Federal Judicial Selection Commission. And anytime there was a vacancy in the federal court in Kentucky, or on the Sixth Circuit bench, was what was called a Kentucky seat, because it was usually held by somebody from Kentucky. Anytime that happened, this Federal Judicial Selection Commission would put out the word to all the lawyers, and all the lawyers who wanted to could apply for that position and do so in confidence. Their names were not revealed. There was an application form that they would fill out and send in, and I was on that commission. 4 of the federal judges in those days came through that commission. And I remember one time we had 40 applications. And we would go through all those applications and get out of that whole group about 10 whom we would interview. And then select, according to the charter, select 3 to 5 whose names we would give to the senators, and by virtue of that charter, the senators would pass those on to the president, and the president then would make his selection from the 3 to 5 that had been proposed by the Federal Judicial Selection Commission. And that worked until there was a vacancy on the Sixth Circuit, and one of the senators had his own candidate, and the commission folded as a result of a disparity of ideas. His 3 people resigned, and he wouldn't appoint replacements, and so the commission was then a matter of the past. But it was a good thing to have. There are some good things in history, and of course there are some good things today that are far better than we can find in history. Part of it is generational. Part of it we old people find very comfortable, and because of that comfort we don't like to see change. On the other hand, when we were young, we didn't have the same comfort with the things that were in effect at that time, and we wanted change. So it's a generational thing. It doesn't mean that young people are good and old people bad, or vice versa.
So what changes have occurred in the law during your practice that you've seen, for better or for worse?
Well, apart from the ones that I've already mentioned, far fewer cases are tried nowadays than were when I was first beginning my practice. And that's because of changes in the jurisdictional rules. And that's partially a result of economics. $1,000 case today doesn't have the same perceived value that it had when I first started practicing law, because economics has changed tremendously, as everybody knows. I would say to young lawyers, if that's what this question is, I would say to young lawyers, you're a part of a marvelous profession. It is the law that is the cement that holds a community together. And at the same time, the law permits people to live together in such a way that they can be community and at the same time have their individual needs met. Law is the lubricant by which they can live together in this society. There was a time when there were three professions referred to as the learned professions: medicine, the ministry, and the law. Probably referred to as learned professions because in those days, those who practiced in those professions had to have training that others didn't need. And it was a wonderful thing to be a part of any one of those three, and still is. Ours serves a function of which I'm very proud, in that it provides for the peace and good order of a society. And without the law, what once was a society falls off into various pockets of egocentricity, where that everybody looks out for his own selfish interests, and it becomes the quote law, end quote, of the jungle, because only the strong can prevail. And in a society where there is law, that changes things. That's the reason our country is different from other countries. Because this is a country that has long believed in the rule of law. We didn't make it up, but this country has held to it, and hopefully will continue to.
Well, I'm going to ask just a couple more questions before we finish here, kind of along that same idea of access to the law and community support. In the early days, I guess pro bono was handled a little bit differently than it is today. We have a pro bono service. But along that line of equal access to the law, do you have any stories about the way pro bono was handled, or even the way some of the people you don't necessarily think would have a voice, maybe in the 50s, that you represented?
Well, pro bono was seen as a professional responsibility. So on Saturday mornings, at motion hour, if some defendant was brought in for arraignment or for a motion or something, and he didn't have a lawyer because he couldn't afford a lawyer, the judge would appoint a lawyer. That sort of thing got me into 3 murder cases, and I was a young lawyer, and And I was appointed to handle those cases. Usually, the judge would appoint a young lawyer and an older lawyer because he was trying to be fair to the defendant, but at the same time, he couldn't pick out a John Y. Brown and appoint John Y. to represent all of the people who couldn't afford other lawyers. That wouldn't be fair to John, nor to the people who paid him. And so all of us had cases like that. Not a lot, but some. It changed during the course of the time I was practicing, and I really cannot account for it except to say that as specialization grew, fewer lawyers could well represent somebody accused of a crime. And so as the bar grew and as the number of judges increased, there wasn't one time a week where all the lawyers were together, because there would be 2 motion hours, and then when we had 3 divisions, there'd be 3. Or maybe we went from 1 to 3. No, 1 to 2. And so some things that changed not because of a plan for change, not because somebody or some group put together a rationale for the change. Some of it happens as a result of other changes that don't appear to be related but develop a relationship. And I think that's a part of what happened here. I don't believe it's because lawyers all of a sudden decided, I'm not going to take cases for free. I don't think lawyers decided, I don't have a professional responsibility to represent indigent clients. I don't think that happened. I think as it developed, and as some lawyers developed a competency in doing criminal law, there developed with that an organization, and they looked for their salaries and their reimbursement from the government because they were doing something that the law required in representing indigent people. And when you do something that the law requires like that, and there isn't any other source of funding for it, it has to come from the government, I suppose. And that's the reason the government grew.
Well, do you have any memories of the Fayette County Bar Association that you might want to share with us? Have you always been a member of the Bar Association?
Until I retired, I was, yes. As I was on the Board of Governors at one time, and I saw a picture the other day of the group that was on the board at the time, none of whom you'd remember because we were all so old that I may be the one of 2 or 3 who survived. No, I think the bar associations, the Fayette County Bar Association, the Kentucky Bar Association, and the specialty bar associations all do good. I think that they help insofar as collegiality is concerned, because it's good to have other people doing the same sort of, serving the same sort of professional interests that you're serving. And to know them and to spend some time with them. And you know, you can do it by going to a bar in after work in the afternoon, and we've done that too. You know, I can look to a lot of my friends that I got to know them at. I don't guess I ought to. If I name one bar, that'll be commercialization, and I don't want to do that. And besides that, there probably were more than one. The bar associations, I think, serve a good function too, because they provide some standards that are very helpful. None of us, when we first go into the bar, when we first start our practice, none of us know all of the ethical problems that are going to arise. Now, we may have had a course in ethics in law school, although for a time there was no such course until the Kentucky Bar Association had a committee that met with the deans of the law schools to see if they couldn't get that started again. But it's the organizations that agree on the standards of the profession. Not only agree, but articulate those standards in such a way that all who want to remain a part of the profession know what's required of them. But that's very important because we're human beings, and we have the same temptations to look after our own interests as those in other areas do. And it takes a while to come to the realization that in the three learned professions, you're not looking after your own interests. You're looking after your parishioners. And if you had to get up out of bed at midnight to go out and take care of somebody that needs your care because you're the pastor of a church, you do it. And you do it as a part of that service, and you're glad that you can be called upon in that way. If you're a doctor and one of your patients is in an automobile accident and you're called out in the middle of the night, or for whatever reason you're called out, you're doing it for the benefit of your patient. And lawyers have to know that the ethics of the profession call for service to clients before service to self. That's important. That's one of the things that makes this such a great profession, is that we come to realize that we're here to serve the interests of our clients. And if we never come to that realization, we never have the joy of being a real lawyer.
That's great. I think we should just end it right there. Unless you have something else you'd like to add.
No, I've talked far too much.
I think that is wonderful. I think we might have to make every young lawyer review this interview. This has been really very good. I appreciate it.
Well, thank you.
And I think that's it. I think we'll stop there before we wear you out.